Thank you very much. Good morning, ladies and gentlemen. So I need to give you all an instruction, members of the jury. You will notice that certain of the co-defendants are no longer before you for reasons that do not concern you. The prosecution of those co-defendants is no longer a part of this trial. You must not speculate, make assumptions, or draw any conclusions about the possible reasons for their absence, and their absence from this trial must not in any way affect your judgment or influence your verdict as to these defendants in this case. You must base your deliberations and your verdict solely on the evidence presented, and an individual determination of guilt or innocence must be made as to each defendant. All right, somebody from the state, if you all want to get Mr. Lee back on the stand, we will finish up with his testimony. Before we broke for lunch, we were hashing through a bunch of Instagram conversations, and I was reading one out loud and basically saying it as my eyes were going over it for the first time ever, and just reading whatever was on the paper, and I read out the word NIGGAS, which I hope that was not offensive to anyone. It was certainly not meant to be offensive to anyone. I do not use that word, and it was merely I should have been looking first before I said it, whatever I said out loud, to edit if there were, any offensive words. So I want to apologize on the record for that. Okay, and is there evidence that he fell onto the curb after being?
Yes, he fell to the ground. That's when I think.
Well, everybody, I would assume, after they're dead, collapses. Anything about a curb is what I'm asking about.
I believe he was outside between, when you look at the surveillance video, his vehicle and that other vehicle, which was close to a curb, is what.
So it's a stretch.
I mean, I think maybe sidewalk didn't fit into the lyric very well, so curb.
Well, he didn't fall on the sidewalk either, did he?
He did. He was outside.
Well, that's what I just asked you.
He was outside.
I knew he was outside.
He fell into a parking lot.
Yeah, parking lot. Was it the curb of the parking lot or just the parking lot?
The curb in the parking lot meet.
I know. And was his body in the parking lot or on the curb?
He was on the curb.
He was in the parking lot. He was on the curb.
Okay, that's what I asked, is did he fall onto the curb? And y'all are now saying yes?
Yes. I would disagree with that.
All right, can somebody pull up the video?
I sped the video up so it could go faster, but I don't think Shannon did this, and let me tell you why. There's Drink's car, there's Shannon, there's Nichols. They're all sitting at a light. Nothing suspicious going on. Simone wanted us to concentrate on the cars going by in front of them and not this speeding car that's getting ready to come up to a red light behind Shannon and them. Shannon takes off. The other car tries to take off after this car pulls up. Look at Shamel Drink's brake lights. They start flashing on and off because he's trying to leave too. And this car makes a U-turn trying to get away from the shooter. Why is that car still on the side of this car? And why are they not a suspect? Still there. Come on now.
There's nothing more powerful than the odor of mendacity.
All right, welcome back Inside the Law, everyone. I'm your host, Philip Holloway. This, of course, is your LawTube channel where we take you inside the real justice system to show you what it's really like in real life, not just how you might think it is if all you do is watch cable news. Look, this is a big week. We had a lot of stuff going on. Obviously, there's the presidential election. The results of the election have significant ramifications for the president-elect Donald Trump. Now we're going to get into what this election means for all of his pending legal cases, not only just in Fulton County, but elsewhere. But of course, before we do that, this wouldn't be Inside the Law if we didn't start out with an update, if you will, about what I used to call the Fani Willis versus Young Thug trial. Now that Young Thug has entered his plea of guilty and has been released from custody. Of course, that was the subject of our show a week ago today, just last Sunday. It wouldn't be the same if we didn't start out, though, talking about what's left of that case. You saw just a little bit of video that was pulled from around the web. The last clip, I want to make sure I give credit for that to Yeah, I Said It on Twitter. That's the person's name. And I saw that was a pretty interesting analysis. But of course, there's no better person to give us the latest analysis than our friend here inside the law, YSL Doug Weinstein. Doug, good afternoon, sir. How are you?
Good afternoon, Phil. I am doing great. How are you doing?
Oh, I'm doing all right, buddy. Look,
Good.
I ran into Doug. I was down in Fulton County on an unrelated matter on Monday, and I just had to go and stick my head in to see what that courtroom was like, Doug, with just the two remaining defendants. And I must say, it was there seemed to be a lot less interest. The extra security checkpoint outside that courtroom did not seem to be as busy. And even the security officer out there was seemed to be sort of half asleep. There didn't seem to be a lot of interest. But you were very interested, of course, in what was going on. And that was the same morning that the judge read that instruction to the jury about to basically to disregard the fact that everybody but the two remaining defendants were gone. So can you tell us what it was like when the jury walked in and saw the absence of so many faces that morning?
Well, yeah, I was actually looking out for that when the jurors came in. They didn't seem surprised, really, which I guess would be expected because try as they might, I'm sure they were unable to at least glance or hear something about these guys pleading out or no longer being there, at least. So there was no look of shock or surprise on the jurors' faces, and that's fine. I'm okay with that.
Well, I've got to imagine that one or more of the jurors. I mean, they're not stupid people, right?
Right,
They have common sense. They have some ability to. That's why they made it onto the jury. Hopefully, is because they do have some good common sense, and we don't want them to leave that outside the courtroom. And so when they walk in and they see this is going on, they can do the math. They can see what 2 and 2 is. They can add it up and they can basically figure it out. And I think I heard it reported somewhere, maybe you can speak to this, but is it still the case that the state is now streamlining their case a little bit and might be expecting to rest a little sooner?
Yeah, they've definitely streamlined their case. It took them a while to decide what they were going to do, but they've definitely streamlined it. We heard from some witnesses last week. There are witnesses lined up for this week. I would not be surprised, based on the witness list that I've seen, if we see the last of the state's witnesses this week. Um,
Wow.
it could carry over into early next week. It's possible, but I would not be surprised to see them rest their case end of next week or at the very latest early next week.
Well, there might be, I mean, I think that it makes just good sense that if you have multiple defendants, not all of the evidence is going to apply to all of the defendants allegedly, and so when you cut down on the number of defendants, you cut down on the evidence. But Doug, I think there might be something else that may have inspired them. So I've got a little video that I want to share with everybody. It's about a minute long. And what I want you to do, folks, is to turn your volume up so that you can hear the audio from inside the courtroom, because it's not as good as the other clips I just showed. And then turn it back down when Doug and I come back in about a minute. But go ahead and check out what the judge got a note. Let's just put it that way.
It's to my assistant. When you have a moment, please relay this to the judge. Good morning, Judge Whitaker. I am requesting to be removed from the current case due to the length of this trial and how the state has handled this case. I can no longer be unbiased towards any decisions moving forward. Yesterday provided a glimpse of how the state presented its evidence, and I foresee another 3 to 6 months with the remaining defendants. Thanks. But then that's not what he really meant to send, because he said, I didn't mean to send this version, not the other one, with a minor correction. Hope all is well. When you have a moment, can you relay this email to the judge? Good morning, Judge Whitaker. I am requesting to be removed from the current case due to the length of this trial and how the state has handled this case. I will be biased towards any decisions moving forward. Yesterday provided a glimpse of how the state presented its evidence, and I foresee another 3 to 6 months with the remaining defendants. Thanks.
All right. So there you have it. A judge has reached out to the court, said, look, I basically can't be fair to the state because they're wasting my time. That's how I understand. That's my interpretation of that note. Doug, what happened in court when this was brought to everyone's attention?
Well, there was some discussion at the bench, and it was decided to bring the juror out and ask the juror some questions to voir dire the juror, or voir dire the juror, as they say in Texas. So the juror was brought out, and the juror was basically asked, look, if we wrap this thing up in 2024, can you manage that? And the juror explained that he enjoys his job, he misses his job, he wants to get back to his job, but the judge said, well, this will be wrapped up in 2024, and the juror said, okay, I can handle that. Then the juror was asked, essentially, as I recall, can you make a decision based only on what you have learned in this courtroom, which is the right question to ask.
Yeah.
The juror indicated that he could, and that was that. There was some protestation from the state at times, and the judge responded with something to the effect of, look, the juror was unbiased before they came in and started this trial, and if the juror is biased against you because of something you've done in this court, that is wholly appropriate. And that's and she didn't use those exact words, and that's again an accurate statement of the law, right, Phil? So
Yes, it is. Well,
so
what
that
we try
juror
to
is still
do when we
here,
try,
and God bless that juror.
when we try these cases, we purposely want the jury to become biased against the other side. I mean, it's you start out from a place of neutrality, at least in theory, and where you wind up is going to be a place that's usually not neutral, right? So
Yeah.
Look,
So what I was trying to figure out was, what did the juror hear or see when the juror said yesterday that put them in that position? And I don't know what it was. And there's a part of me that kind of hopes that what sent him finally over the edge was the issue about the missing watch. Are you aware of the missing watch, Phil?
I'll let you explain it. You're more prepared on that than I am.
Okay. So when Jeffrey Williams' home was searched May 9th of 2022, and goods, things were seized from the home. Weapons were seized from the home. Drugs were seized from the home. But also cars were seized from the home. And there was in addition to all of this, there was a lot seized from the home. There was a closet somewhere in the home that was full of jewelry, millions and millions and millions of dollars worth of jewelry, which for some reason, which one can only imagine what it would be, the state essentially inventoried that as, blue box of jewelry and red box of jewelry. But you can clearly see in the video that there is a Richard, and I'm going to probably pronounce this wrong, there's a Richard Mille watch, a $500,000 watch that was a gift from Drake to Jeffrey Williams, to Young Thug. And I did not see that watch in the inventory list, so I raised a bit of a stink about that watch being missing. The prosecution, I guess to redeem the state and law enforcement, had the jewelry boxes brought down from wherever they were in storage. And then I had the witness go through those jewelry boxes, and the witness confirmed twice that the white ceramic Bubba Watson Richard Mille watch was missing. So somewhere that watch went missing, and whether it went missing because of law enforcement, I mean, I don't know where it went. Well, I have ideas. I have theories about where the watch went missing. And there will be more to come on that. So maybe that's where the juror just said, okay, that's just one straw too many. That's one. I don't know why that would be it. It could have been any number of things building over the past year that made the juror come to the conclusion that something smells here.
Well, something has smelled in this case for quite some time, and you can just add that to the ever-growing list. I mean, you never know what it's going to take, which straw is going to break the camel's back. But I'm very interested to hear whatever future developments there might be on that. But I wanted to ask you a follow-up to one of the videos that I showed in the intro.
Mhm.
It looked to me like basically there's this maybe a debate about what rap lyrics might mean and how they could be probative. Did I get that wrong?
No, I mean, yes, that is exactly, you got it exactly right. There is an issue about the probative value of the rap lyrics. We've litigated this extensively. I have argued this. Max has argued this. We lost before Judge Glanville on this issue. We're not really relitigating them, but I think Judge Glanville may have left the door open up a little bit that if there's some specific lyrics, maybe we can discuss that. So we got into this theater of the absurd conversation about certain of Shannon Stillwell's lyrics. And, I think, and you played the perfect clip of that because there's some lyrics having to do with, a body on a sidewalk or a body on a curb, painting the curb like Picasso. I can't recall the exact lyric, something that may allude to a drive-by in the lyric. But you saw we had this, I don't know how long it took, 10-minute discussion, 5 to 10 minute discussion, pulling up crime scene sketches about a lyric. Was it curb? Was it sidewalk? Where was Donovan Thomas's body located? And I think this just goes to the absurdity of using lyrics because one of the things brought out, curb rhymes better than sidewalk. You
Yeah.
know, that was from the prosecution. Actually, I recalled it as being from the judge, but that was from the prosecution. And it shows you that, the use of certain words in rap lyrics or in any lyrics, it's not about necessarily or even possibly depicting a factual. There's lots of things that go into it. And one of the things that goes into it is rhyming.
Yeah.
And if rhyming is a consideration, are those words you really want to use in a trial about someone perhaps killing another person? I don't think so. So many issues with rap lyrics. Max, I'm going to talk for one more second. Max kept honing in on nexus. I'm always about nexus, meaning I think if you look at the best case law on rap lyrics, judges have required a finding of a nexus, some connection between the lyric and the accused crime. So you look at a lot of the lyrics they've attempted to use against my client with bodies on bodies and these running from 12. These are very generic rap lyric tropes. There's no particular nexus between that and the crimes alleged against my client. So typically they require a nexus. Max has tried to demonstrate that there's no nexus here. The state of Georgia has not found in our case law yet a requirement of a nexus. But if you look at some of the bigger cases with rap music videos, for example, there's been a definite nexus when those have been allowed in. So, but again, as I've said before, Judge Whitaker does not want to relitigate all of the things litigated previously in front of Judge Glanville. So I believe these lyrics are coming in. I'm glad she at least entertained keeping them out.
Well, look, I'm not going to play the whole thing, but she used one key word. I'm going to replay just the beginning of that clip because I want to talk about this word that Judge Whitaker used.
Okay, and is there evidence that he fell onto the curb after being?
Yes, he fell to the ground. That's when I think.
Well, everybody, I would assume, after they're dead, collapses. Anything about a curb is what I'm asking about.
I believe he was outside between, when you look at the surveillance video, his vehicle and that other vehicle, which was close to a curb, is what.
So it's a stretch.
There's the word. It's a stretch. Well, 3 words. It's a stretch. She called it a stretch.
Yeah.
And I think that's look, this is the First Amendment. We're talking about artistic expression and, there's to me, when you've got the Constitution like this involved in the First Amendment, free speech, free expression, it ought to be something that's really, really compelling and really, really probative. I think that obviously a nexus is important, but it really ought to be more than that, in my view. That's just my opinion.
Well, I am being as, I don't know what I'm trying to say, reasonable, I guess, as possible, just based on the case law. I agree with you that there needs to be more, and it's why I continue to support passage of the RAP Act within Congress, which is a bipartisan piece of legislation that I would like to see move through Congress. It's supported by the music industry, and it essentially changes the rules of evidence to create a higher burden before you bring in people's artistic work against them in a criminal case. And it is a result of compromise, and it is a very reasonable change to the rules of evidence. At some point, maybe if I ever come up for air, I will do a TikTok on the RAP Act. It's on my list.
No, listen, and look, and this in a minute we're going to get into Fulton DA Fani Willis and her reelection in this past week. And how, I mean, to me, it certainly is interesting that everything is wrapping up here right around the same time that
Yeah.
occurs. But I can tell you that, look, I ran into her challenger the other day, Courtney Kramer, and Courtney tells me, and that's nothing that's, I guess, not public information. So in Fulton County, Donald Trump won, I think, 27% of the vote last Tuesday in Fulton County. I think that Courtney wound up getting higher than that. I think it was around 31 or 32%. So
Yes.
that should tell you that even in a heavily Democrat county like Fulton County, Willis is not making any friends with some of these cases, this one included. And among those that are no longer, or maybe never were her friend, is the rap industry, the music industry. They are particularly upset with how she's using rap lyrics. And I think that there's been some movement even in the state legislature as well here in Georgia. And I'm looking into that some more. I've got some legislators that I've been talking to see what the status is of that. But there's a move both in the state of Georgia and on the national level to protect some of this artistic expression from being, evidence in a criminal trial when the nexus is dubious or specious, like I think it is here.
Yeah, and I think most reasonable people would agree with the use of people's artistic works against them, requiring some higher burden than just ordinary. I'll call it ordinary speech. So yeah, I hope we get there. I don't know if it's going to be. I have a little more hope for Congress acting than I do for the state of Georgia, but maybe we can get it through there as well. And yeah, I did see Ms. Kramer outperform President-elect Trump in this election, which tells you, I think, that I don't want to digress into politics, but it does show some vulnerability, perhaps, that Ms. Willis has should she still be district attorney in 4 years.
Yeah. So, look, we can talk for a long time about rap lyrics and the First Amendment. In fact, joining us here in just a few minutes, my friend and our colleague, attorney Julie Hamill, who's a First Amendment lawyer in California, is going to be back here inside the law. And I know this is something that she's also going to be very interested in. And so maybe we'll just have to talk. We'll have to set aside a whole new show just to talk about this, because I think it's very, very important. We got to make sure prosecutors keep things keep everything fair. We don't want people's words, particularly when the words are unclear and it's artistic expression, just that being evidence of a crime, to me, it seems like it's just a bridge too far. But you mentioned, Doug, that you think what's left of this YSL case might be wrapping up pretty soon. So assuming, like you said, maybe this week, and if that's the case, then of course, what happens, for those who may not know, what happens is the jury goes home again while the lawyers and the court figure out what the the charge will be. That means the written instructions that are read to the jurors. It tells them all the basic stuff, like, you got to hold the prosecutor to a proof beyond a reasonable doubt and all these kind of things. But then the charge has to get tailored into the very specifics of the crimes that have been charged. Doug, do you have any thoughts that you can share with, like, how long that process, we call it the charge conference, and how long that will take? And then I want to know how long it's going to take to read all that to this jury. You have any thoughts on that?
I do. Can you hold on? Sorry, bear with me 1 second. You cannot get out. Sorry, I have blocked my. I apologize. I have blocked my wife in the driveway. You want to take the Nissan, or you want me to move this? Can you give me 2 minutes?
Of course, Doug. Go ahead. Well,
This is what's so great about live TV. Okay.
I'll see you when you come back. Doug will be back in just a minute. And by the way, for those of you who are asking, Rachel has other plans tonight. She gives her best, and she will be back, but she has other things going on today. I saw someone asking about that in the chat. I wanted to, while we're waiting on Doug to come back, there's, this. Thanks, Nick, for the super chat. I appreciate it very much. So I don't know the number, but I don't have any reason to dispute what you say here, Doug. Nick, when you say more than 2,000 untested assault kits in Fulton County, Georgia, and I have to use that word. Look, it's, if you have 2,000 of those kits that remain untested, that's a big problem. That's a political liability. That's the kind of thing that voters can really sink their teeth into. That's the kind of thing that legislators can sink their teeth into, and that is potentially a big political liability. So we'll just have to see how that plays out. But it's been an issue that's been sort of brewing here in Fulton County for some time. And when we get Rachel back, she's, I know, very keen on this issue. We're going to be talking more about that. But thanks, Nick, for the super chat, and thanks for the comment. So Nancy asks, how bad could this case be for the economy of Fulton County with the entertainment industry thinking about moving out of the area? Well, I think that, I don't know that that's the case. I think the entertainment industry, there might be some that come and go, but the state of Georgia has doing a lot, just like California, I heard, is also doing to keep the entertainment industry where it is. And so there's tax breaks, there's all kinds of things. So I'm not sure that the entertainment industry is going up, but thanks for the comment, of course, and thanks for the super chat. I want to, while Doug is sorting out his parking situation, at home, I want to welcome back to the show, everybody, my friend and attorney, Julie Hamill, who practices in California. She's also very much involved in First Amendment law. Called Grace. Julie, we were talking before you joined us, Julie, we were talking about using rap lyrics in the context of criminal cases. And I know you're here to talk about what the election means for the future of the Donald Trump cases, but do you have any, and I'll go ahead and add Doug back too, he's back, but Julie is about to give us an answer that I'm surprising her with this question, if she has any thoughts on using rap lyrics as evidence in criminal cases.
I don't do this kind of law, but I've read and I understand that there is a body of law regarding these issues in California. And I know that there's a big push to not be able to use rap lyrics as evidence in a criminal trial. But I'm going to sound ignorant because I'm a civil attorney. I don't really dabble in criminal. But I think if there is a specific explanation or retelling of a story that recites facts that align with the facts of a murder, for example, perhaps that could be something that might be used as evidence in the case. But I think in general, if you're trying to go after someone who has rapped about violent experiences and try to use that as, evidence of this character or something along those lines, then that's problematic.
Yeah, Doug's back with us now. We're talking about this YSL case here in Fulton County, and Doug was arguing that there needs to be some nexus, that ties it up. And look, if you confess to a crime and you bury it in your lyrics, well, maybe I could see that. But if you've got to try to interpret what something means to tie it to a crime, I just see there's a big First Amendment problem with that. And Doug was talking about the RAP Act that is something that might get pushed through Congress one of these days.
Yeah. And by the way, California does have a version of that RAP Act. And I think, and I know I'm going to get the order wrong as soon as I say it. I think the California version came first, and the RAP Act is somewhat modeled on the California version, but that may be backwards. But California got it enacted into legislation, obviously, before Congress has acted.
California likes to do all the crazy stuff before it goes national.
I love that. What is it? The states are bodies of experimentation or something like that.
Yeah.
All right. So speaking of states, the states each conducted elections this past week, and there was a winner, and the president-elect has some outstanding legal matters that are now somewhat in limbo. I want to get into all that, but before we do that, I wanted to share with you just a couple of minutes or moments. I was live streaming with Megyn Kelly late in the evening, around 11:30 p.m. Eastern time, when the results weren't quite known yet. But I joined the legal panel with her to talk about this issue, and just hear some of what we talked about.
Say this: look, President Trump's either going back to the White House or he's going to Rikers Island, and I think the American people are going to determine that tonight.
Okay, Phil. So Fani Willis has not given this whole thing up. We had the judge who refused to DQ her, and it's being appealed, and it's not yet resolved. So what's going to happen with the case in Atlanta?
Well, so next month in December, there's oral argument before the Georgia Court of Appeals on the very issue of whether or not Fani Willis, should be disqualified from further prosecution in this case. And look, the judges who are on that panel all come from pretty red areas of the state of Georgia. I'm not saying that politics creeps into the judicial system, but hey, sometimes it might. And I think, particularly, that if he wins this election, and it looks like he will tonight, I think that the Court of Appeals in Georgia is just going to have all the more reason to go ahead and disqualify Willis. And if that happens, this becomes an indictment without a prosecutor, because the Georgia, they have a state agency called the Prosecuting Attorneys Council. They would be tasked with potentially assigning it to another prosecutor, and no other prosecutor in their right mind in the state of Georgia is going to want to pick up the mantle and try to carry this prosecution across the finish line. They would have to start over from the very beginning, probably anyway, to clean up the mess that's been made by Willis. On the other. All right, so that's just a little bit of what we got into. And look, so we may as well start out with this case. And you heard my opinions on it there, Doug. What do you think?
Well, I'm pretty much in agreement with you. First of all, Megyn Kelly, it's Fani Willis. I mean, let's have a minimal amount of respect for the office, I guess. Anyway, so I think the Georgia Court of Appeals should still hear the case. I think they should still issue an opinion. I don't believe it's moot, but this case is dead in Georgia. I mean, it's dead, no matter what happens in the Court of Appeals. I realize that the state doesn't have the same policy as the DOJ, but you cannot continue. I mean, the DOJ policy has to be the model for the state to follow, and it's just nuts to continue this case in Georgia. Now, I don't know how you wrap it up. I guess you null process it. I'm not really sure what you do about it, Phil. But it's over. Whether it and you're right, Pat GA, I totally agree with you. No sane prosecutor in the state of Georgia wants to take this case if Fani Willis is DQ'd.
Julie, I know that you got something you want to say. What is it?
I I love talking about Fani Willis and I love talking about this case because the odor of mendacity permeates and will never go away. And I'm still hung up on the fact that she has hordes of cash in her house that she used from her campaign, that she uses, in case of emergency. And I don't know what the status of the ethics complaints are. I assume that they are still pending. But this case is so, it's just, there is no way to make it look not corrupt at this point. And I find it very entertaining. I know that there are still serious criminal cases pending down there against real people who are still very concerned, and I don't find that entertaining. And I hope that they are all acquitted and don't have to pursue this absolute clown show that's going on in Fulton County. But there's no way to make this look not corrupt, even if it weren't corrupt. It's so damaged by the behavior and the conduct allegedly by Fani Willis and her paramour, and all of the dirty details that have come out of that case.
Well, we might be clear of the allegedly territory on that point, but look, I mean, that's going to be the big issue before the Court of Appeals next month is is whether or not there's, the appearance of impropriety is enough to get her tossed off the case. And then what would happen, and Doug, feel free to correct me if I get this wrong, but I think what could happen if it's tossed, then Willis and her team could appeal that to the state Supreme Court, to the Georgia Supreme Court. Now that would be a discretionary appeal. They wouldn't have to take it. So if it gets tossed by the Court of Appeals, that might be the last stop. On the other hand, if Willis were to win at the Court of Appeals, then the reverse would be true. The various defendants could ask the state Supreme Court on a discretionary basis to take it up. And I think that the Georgia Supreme Court, I think the Court of Appeals is going to toss it, but if they don't, I'm almost certain that the Supreme Court would toss it if it ever gets there.
I know, but when you say toss it, you're talking about disqualifying.
Yeah, I
mean,
Willis, right? Disqualifying Willis, correct? Yeah.
So disqualifying Willis doesn't kill the case, but I mean, she has botched this case up so badly. I mean, she took way too long to indict it, for one thing. I mean, if there's something there, I don't know why it took this long to do. She's the one that pushed it so close to the election. She's the one that hired her paramour. I'm so frustrated with her that I can't even begin to tell you, because I personally think there's something there, but she's totally screwed it up. So I don't even trust that anymore. I don't trust any part, and I'm a Democrat, right? It's not a secret. I don't trust any part of this process anymore. I don't trust the grand jury process. I don't trust Nathan Wade's involvement. I don't trust her involvement with all the stuff that's coming out about basically gauging public opinion on whether or not to indict the president. That is not something that should factor in. And President-elect Trump becoming president-elect, I guess, again, that probably gets him out of it. I don't know what she does with the rest of the defendants. If she is smart, she would just walk away, cut her losses, and call it a day. Lesson learned.
Yeah, I made that same point talking to Ashley Merchant over the weekend. I said, look, if she's smart, she's just going to go ahead and dismiss the whole thing, and you guys won't have to argue this next month. I'm sorry I cut you off, Doug.
No. But that's, let me put it, instead of saying if she's smart, let me say if she does the smart thing. And I really cannot, judging from the YSL case, I will not count on her doing the smart thing.
Well, we will see. Julie, let's talk for a minute about the case that's going on up in New York. There's a sentencing hearing that's scheduled for later this month, or maybe early December. I'm sure somebody in the chat will correct me. It's all running together, but I know there's a motion hearing before that where the Trump defense team has asked Judge Merchan to toss that case on the grounds of presidential immunity as set out in the recent Supreme Court case. Julie, what do you think is going to happen up there in New York?
I have no idea. All I know is that all of these cases, and by the way, for the record, I voted for Biden last election. And I had severe Trump derangement syndrome, which has since gone away and left my body. And so I'm not like a Trump super fan. I'm just an evolved person who sort of sees policies that harm my family and have chosen a different path. But to me, to a person who had vitriolic hatred for this man, because I was consuming all of this media that was forming my thoughts in a subconscious way that I really was not aware of. To me, all of these cases are so nakedly partisan and so out of control, ridiculous, that I hope that the right thing is done. Ultimately, I think it will be done. But in this case, New York essentially created a new cause of action. Like they created this new body of law to specifically target and go after Trump for these specific things. And I don't know how that's going to play out. I assume it's going to be some sort of fine if they do proceed with sentencing. He's not going to be locked up.
No.
Oh,
I
no,
don't.
no, I agree.
I hope that the people in New York are smarter than that. But what I really hope to see is not just a pause or a, hey, okay, now he got elected, so we're just going to hold off. And then once he's out of office, we're going to pick this back up. We need to see an end of weaponizing the government for political purposes. It's absolutely out of control how far these things have gotten in this country, and it scares me. And I hope that there is an awakening on the left where they realize, maybe we took this a little bit too far and we did weaponize all of our government resources to politically harm this one person and to try to lock him up so that he couldn't be president again. And that's probably not a good idea.
Yeah, well, I think Doug, is like you say, it's no secret Doug is a Democrat, but he's still our friend and he's a great lawyer. And
Thank
I know
you. I
that
appreciate that.
Doug agrees with the fundamental fairness of the system. I mean, if you don't have that, you can't weaponize it against political enemies. And if I've said the same thing about this case in Fulton County, if it were a Barack Obama or a Joe Biden that were being prosecuted for the same reasons, I would be just as opposed to it. But I think, we were talking about Willis and whether or not if she can do the smart thing. I think that if I were a Judge Merchan and I were presented with an opportunity like he's going to have to dismiss this entire thing on some other basis, such as the immunity grounds, I might be willing to just go ahead and do that. Give myself an out, let everyone off the hook. And that way you just don't even have to answer these questions about sentencing. But, who knows what it's going to be? I think that he's got other options. He could just do a fine. I think he could do something like we have here in Georgia, Doug, where it's just like some kind of a deferred adjudication where he doesn't adjudicate anything. And if nobody gets in trouble, it's dismissed down the road. We would call that some states call it deferred adjudication. In Georgia, it's called, not first offender, but what's the other one, Doug?
We have diversion here in California.
Yeah, I mean, I generally think of it as a diversion type
Yeah,
program.
exactly. Something along those lines.
I don't know what options he has up in New York State to even speak intelligently to it, but I never expected President Trump to be sentenced to any type of a time in jail or prison. So I've always he could do some type of non-reporting probation, I guess. There's lots of options he has. I was looking back, and I don't remember anymore but I was looking back when all this was going on, and there's been 150 people that have been prosecuted under the similar provisions of New York state law. So he's not the first, but in the vast majority of the cases, no one served any time for it. There have been fines, there have been probation. And in addition to that, the few that have served time, no one that's 80 years old that has no criminal history would ever serve any kind of time for this. So some kind of fine, some type of probation, or I don't know what would be appropriate. I don't expect with this Judge Merchan up in New York, just having, again, looked at him previously, I don't expect him to look for some political way out to avoid sentencing. I think if he does decide on immunity based on the recent Supreme Court decision, that if he makes that finding, it'll be based on the law and not based on him trying to worm out of anything. But that would be an easy out if
Oh,
he finds under
I would
law.
worm so fast. Look,
Yeah.
if I have a hot potato on my hands, I'm going to try to get rid of that as quickly as I can.
Yeah.
But speaking of that, we in the Florida, we call it. Let's move to the feds now. We have this Florida, we call it the documents case that got dismissed, and Jack Smith, special counsel, has, I guess, he took that dismissal up on appeal that's pending here in the 11th Circuit, which is here in Atlanta. I'm sorry, the 11th Circuit Court of Appeals here in Atlanta. As I understand it, guys, help me out if I got this wrong, that DOJ policy is they can't prosecute him, and they're not going to, it looks like, at this point. So they would have to dismiss that appeal, right?
Real quick, I know in DC, he's asked the judge to, Jack Smith has asked the judge to basically suspend all due dates while DOJ considers what to do under DOJ policy. The judge granted that. And I think he has he asked for the 5th. It was an unopposed motion that the judge granted. And I expect him in DC, it's kind of a no-brainer for him to dismiss that case under DOJ policy. He's got a trickier issue, I think, with Judge Cannon and this 11th Circuit appeal. I'm not quite sure. He has to worry about presidential effect of what he ends up doing. And is it moot because even if the 11th Circuit reinstates it, he wouldn't prosecute it anymore? I'm not sure. I think he has a more complicated decision there. Eventually, it will go away. There's no doubt. But what does he do about this terrible decision of Judge Cannon? I don't think he can let it stay there. So I don't know what he does about that. But I have no doubt all federal prosecutions against President-elect Trump are done.
Julie?
Yeah, and I want to be clear. Here we're talking about the documents case. And
Well, we kind of talking about them both. It looks like
I was bouncing back and forth.
And I mixed up when I said that they created a new cause of action for the New York case. I was talking about his business case.
Yes,
and that's what I was referring to. Also,
a different issue from the alleged cover up with Stormy Daniels. Blah blah blah. But in terms of the documents case down in Florida, the federal case, we have the foundational issue of whether or not Jack Smith's appointment is constitutional or not. But here we also have Joe Biden did the same thing. And then we had that whole controversy with, but he wasn't competent to really be held liable or responsible for losing track of those documents because he's a senile old man. Yet he is still our acting president, and Kamala Harris never actually pursued 25th Amendment action, blah, blah, blah. So I think that is something that the Democrats are going to want to be really careful about, because if they are, if this is purportedly something that is done to everyone and it's fair and it's not political, then the same thing is going to happen to the Biden family. So,
that's why I think the smart thing, the smart play, I think, would be to dismiss the appeal. And that way Judge Cannon's order dismissing the whole thing ends, and you don't ever have an appellate decision on whether or not Jack Smith was appointed legally or not. So, I think the smart play there would be to just dismiss the appeal. But as Doug mentioned, and I just shared this, I had posted this on Twitter a couple of days ago. There's this unopposed motion to vacate the briefing schedule that Doug was talking about. And he says here in his motion, by December the 2nd, 2024, the government will file a status report or otherwise inform the court of the result of its deliberations. So they're by that, they mean they're trying to figure out what to do. They do reference, Doug, that their deliberations are about whatever the appropriate course is going forward, consistent with DOJ policy. I assume he's talking about the policy, which is well known, that the Department of Justice says that they can't prosecute a sitting president.
Yeah, so that case will for sure go away. And I guess the more I think about the Eileen Cannon decision, it is to say it's an outlier would be an understatement, because all the precedent goes against her in appellate courts and even in district courts all across the country. So it's this one outlying decision. I guess if you just leave it there, if you're the DOJ, it's not going to damage you
Correct.
in future
It
prosecutions.
doesn't set
So
precedent. Yeah.
no, it's not precedent setting, and it's freakish, and so you can just ignore it, I think, going forward. She's not a judge that has much credibility. It's not a learned hand opinion. So, you can ignore it. You can go ahead and just go ahead and know that no other court is going to follow it. I don't think she wants to go 0 for 3 in the 11th Circuit anyway. So I think it's fine to drop it. And then just move on. Move on. The people have spoken. They've decided they don't care about any of this. I mean, it was as much of a landslide as you're ever going to see in America in the
Oh, yeah.
2020s.
Yeah.
So, I mean, it was a very clear vote. And the people don't, as long as you don't screw up precedent for the future, and just you're right. Maybe just drop it is the smart thing.
So this is back to the YSL. One of our moderator transplanted Texan flagged this. Could Trump pardon the guys on YSL? So the answer to that is no. The president of the United States, whoever he or she might be, does not have any power over state prosecutors. And people ask me all the time, well, can the governor? And in the state of Georgia, the governor does not have pardon power. That's left to the Board of Pardons and Paroles, and they never exercise that power until after someone would be convicted, and in many cases, years and years and years on. So there's not going to be any pardoning for those guys on YSL. This is just like I think it's a facetious question, but we're back to the First Amendment. Thanks for the super chat. But this is the question about our actors next. I guess they're talking. The issue is we were talking about the First Amendment and going after rap artists and musicians. Actors clearly it would this look when actors are acting, they're reading scripts that somebody else puts out, but. The issue of the First Amendment stuff is not going away, but I just had a couple of super chats that came up about that topic.
Can I speak to that one for a second as far as our actors?
Of course,
next?
yeah.
You mentioned something about actors not speaking their own words. I need to make it clear, and I've explained this to the court. Rappers are not always speaking their own words either. Often they're written by other people. Even when written by themselves, I had Wani Lee testify to this last week. Even when they write them, the music executives, the label is involved in changing the lyrics, pressuring the lyrics to be a certain way, presenting a certain persona to the public. So, I mean, to some degree, these guys can be actors as well. They're not always their own words. And also, I had Wani Lee tested. I'm sorry, go ahead.
You could also say the same for politicians.
Yeah, well, they rarely speak their own words, right? They have speechwriters.
Yeah.
So, and Wani Lee also, I forgot what I was going to say, but Wani Lee also testified. He also testified that he actually, despite being from the hood, possesses an imagination, and not everything he raps about is autobiographical.
Yeah,
despite what some courts may believe.
We bounce back into the YSL, Julie, and because I thought this was and thanks for the super chat. But Doug can tell this story because there was something that came up where Doug was offering the jury some samples, and of course, given the nature of some of the charges in this case, it was really funny. Doug, what was that about? You can tell the story.
In the raid of Jeffrey Williams' house, of Young Thug's house, they had confiscated 24 bottles of a liquid that had THC in it. Completely legal Delta 8 THC, legal in Georgia even. You can go anywhere and buy this type of concoction. So when you looked at the bottles, there were bottles clearly labeled for resale. They had a label, they had ingredients, they had nutritional information. I wanted the jurors to hold these bottles, pass them, pass a few around and see, okay, this isn't drank. In other words, it's not laced with an illegal product.
Yeah.
It's a mock version of what they call drank. So anyway, I asked that, and I inartfully worded it in the words of ADA love. I inartfully worded it. And I asked the judge, may I give the jury some samples, meaning some of these bottles? And I believe the judge's response was something to the effect of, in her nice Southern accent, like, heaven forbid, no, you may not do that. And I didn't realize that I had quite said samples, and I was a little taken aback that I couldn't give these bottles to the juror, but whatever. And then I got home that night and saw, all the social media about Doug trying to give THC to the jurors. And I apologized to the judge the next morning, and she said we could all use a good laugh in this case, and it was all forgiven.
All right. Well, so what's coming up this week? You think it's going to be the end of maybe the state's presentation? And then I want to go to Julie, and we're going to talk about what's coming up in California. So, Doug, what's coming up in YSL here in Fulton County this week?
Okay, so I fully expect the state to finish their case in chief and rest their case, at which point Max and I will move for directed verdicts on one or more of the counts against our clients, if not all of them, given how the state's case has proceeded. So I am working on that. Then we have the opportunity to present our case, and whether we will, whether we won't, who we present, the jurors clearly want to go home, and I'm mindful of that.
Yeah.
So we'll be making that decision once we see if the state gets anything together that I feel we need to rebut, that we haven't taken on cross. And then so next week you'll see some of our case if we present one. And then, as you say, the jurors will be sent home. We will have a probably 3-day charging conference where we figure out the instructions, which I'm giving a rough draft to the judge tomorrow on jury instructions. We'll have that. We'll come back. We'll do closing, and hopefully we'll be done with this by mid-December, and my client can go home by then.
Oh, look, I know we're all looking forward to the end of this case, and I'm sure nobody more than you. You have certainly worked extremely hard and long on this, and so you're overdue, my friend, to be done.
Thank you.
Julie, so let's talk about legal cases.
But I'm going to drop off now. Now since you guys are getting into that.
Thanks, Doug. Have a good week, buddy. Thank you.
Sure. And I apologize for having to move my wife's blocked car.
Look, we all have lives, buddy. No worries.
All right,
It's either that or a barking dog. There's always something here.
Yeah, I don't have the barking dog. I try to control things a little more.
Right, buddy.
Bye.
See ya. Julie, what's going on? So in California, what's on the radar out there as far as upcoming criminal or even civil legal things that people here inside the law can maybe look at to learn something about the court system and the justice system?
Oh, well, politically is more exciting. Can I get into that? That's going to end up in court.
Okay. Well, yeah. So what's going to end up in court that's political out there right now?
So what happened in this election is, as you saw across the nation, almost every single county moved to the right by a significant margin. LA County moved to the left, unfortunately. But the voters in California overwhelmingly rejected our radical leftist Governor Newsom's policy ideas. So we had a George Soros-backed proposition called Proposition 47, which is essentially a soft on crime proposition that has made property crime rampant throughout the state. And then combine that with district attorneys throughout California who are also backed by George Soros with Soros money. And those people had, like in LA County, we had our DA George Gascon, backed by Soros. On day one, when he took office, he implemented a policy that said, I am not going to prosecute any juveniles for any misdemeanors. And when you combine that with Prop 47 that made most property crime a misdemeanor, basically juveniles in California have had free reign. There's been no penalty, no punishment for bad behavior. And it's very obvious. We have many retailers have just completely closed up shop. The ones that still exist here in California have everything locked up. Everything in CVS is behind lock and key, everything in Rite Aid. So the voters on November 5th approved this Proposition 36, which reverses Prop 47 and restores criminal penalties for property crime and for drug crimes. And the voters enacted this measure 70%. 70% of voters approved it. And Governor Newsom had been fighting like hell to keep it off the ballot. So he had fought to keep it off the ballot. And then once it was on the ballot, he led the opposition. So he was trying to convince voters in California to vote no on Prop 36. He wanted to keep the soft on crime policies. And voters in California who are overwhelmingly liberal and leftist rejected that. So 70% of voters enacted Prop 36. We got a new DA in Los Angeles County. Pamela Price was recalled. Sheng Tao, the mayor of Oakland, was recalled. So all of these communities that have been experiencing rampant crime and have had just to deal with the consequences of horrifically leftist radical policies have made their voices heard. It's very exciting. But what I'm expecting to see now is Gavin Newsom on Tuesday discovered federalism. And he made an announcement saying, I've discovered federalism. No, I'm going to fight back against Donald Trump. And we're going to fight back and protect California's radical left policies against the evil man, Donald Trump. And the ACLU took out a whole full page ad, I think, in the New York Times saying something along those lines as well. But what I think is really interesting is, long story short, and cut me off if I'm rambling. I feel like I'm rambling to you.
Yeah, we're good.
So in California, all of our school districts are violating FERPA, which is the Family Educational Rights and Privacy Act, or federal. I'm mixing it up, but it's privacy rights and it's parental access to the educational records of their children, and it's a federal statute. And in the statute, it says that the Department of Education shall provide no money whatsoever to any district who is violating the provisions of this federal statute, which requires schools to provide all educational records pertaining to a child to that child's parents upon request, and does a number of other things. And because of California's crazy gender ideology laws and policies, every single district in California is violating FERPA. And so what I find interesting is now we have our attorney general, our state superintendent, and our governor saying, we're going to fight these feds. We're going to fight the Trump administration. They're going to try to take our money. But California's broke. California doesn't have the money to fight the feds, and they cannot afford to support their schools without federal funding. And so I'm very much looking forward to, personally, with California Justice Center, I'm going to be filing a lot of FERPA complaints administratively, and then I'm going to make sure that the federal government is aware that all of these districts are violating federal law and that they should not be receiving any federal funding whatsoever to continue depriving parents of their rights under federal law and the Constitution when it comes to education.
So when Julie, for those of you who may not ever have heard of the phrase before, federalism refers to the relationship between the federal government in the United States and the states. The states are, in their own right, they are sovereign governments. Each state, when the Constitution was ratified, granted a little bit of its sovereignty, for lack of a better way to put it, to the federal government. So the idea theoretically is that the federal government is a government of limited sovereignty, and the remainder of the sovereignty is reserved to the states, and that's basically through the 10th Amendment. So you're supposed to have limited government on the federal level and most of the government taking place on the local level. But as we know, over time, that has we've kind of come unhinged from our moorings, and the federal government is now much more powerful than I think our framers had intended. So when we speak about notions of federalism, that's what Julie is referring to. Now, let me switch gears for a second, though. You're in the LA area, right? And you mentioned that your DA, George Gascon, was defeated in the election. I'm assuming that his challenger was another Democrat, because there's like Fulton County in Atlanta, it's a Democrat stronghold. But what do you think of what was the impetus behind a Democrat challenging him? Was he just that unpopular?
He was extremely unpopular, but the person who challenged him and who won is Nathan Hochman. And Nathan Hochman used to be a registered Republican. He deregistered. He's an independent, so he ran as an NPP. And he came out on local news a couple months ago to endorse Harris, and that bothered me. But I see the strategy. In LA, you have to make yourself appear as leftist as possible if you want to get elected. And it worked. I think he got 60% of the vote, which is huge. And there was a bipartisan coalition supporting both Nathan Hochman and Proposition 36. So both Democrats and Republicans and independents are all very fed up with crime and lawlessness in LA County. And it's, there's still this push and this effort on behalf of leftist media to try and pretend that, the crime stats are overstated, that crime is down. Everyone has eyes and ears and everyone can see it. And the voters did the right thing on November 5th. And I'm very, very optimistic about how things are going to play out going forward.
Well, I know you got to run. I want to say thanks for hanging out with us here inside the law for a little bit, and I look forward to talking to you again moving forward as we see how these things progress out there, Julie.
Thank you so much for having me on. I love chatting with you.
All right, we'll see you later. Thanks. All right, so there you have it. From coast to coast, we've got issues going on. Look, Julie mentioned this DA's race in Los Angeles, and it occurs to me that we had right before the election, we had George Gascon wanting to sort of reopen and maybe re-sentence the Menendez brothers in the murder of their parents. That case now several decades old, and he filed this motion asking the court to basically do re-sentencing, and that's pursuant to a new law that was new-ish law, I guess, that was enacted in California that allows for that. So I think that I'm going to be interested to see what happens with that issue, because the new DA, I understand, takes office on like December the 2nd. It's doesn't even have to wait till the end of the year. So he's going to be in office in less than a month. And so we'll see if that changes the district attorney's policy, or the DA's office's policy, I guess, as it pertains to the Menendez case. But anyway, look, I want to say thanks to all of you guys. We're going to have to leave it here. If you haven't liked or subscribed, please do so. I'm knocking on the door of 51,000 subscribers. I'd like to get to 55 or 60. So if you know people who are interested in the subject matter of this channel, learning the real justice system from the inside out, suggest a follow for the channel, and I would really appreciate it. And to all of you guys out there and watching the show now or on replay, I just want to say thanks again for your time. We really appreciate it. And I look forward to seeing you back here next time inside the law.